The Richard Allen case had an argument with the Indiana Supreme Court today. We're about 2 hours outside that oral argument. I had to, of course, get lunch before I could collect my thoughts for this video. And I want to let you know I have not reviewed the transcript. All I have reviewed are my handy dandy handwritten notes, about 5 pages long. I absolutely enjoyed this oral argument. I saw a lot of smart lawyering. Let's break it down. The attorney arguing for Richard Allen was Marc Lehman. I never met Marc Lehman, but I love his first name. I thought he did a great job. As soon as they started, Chief Justice asks him, hey, how come you guys didn't file a separate claim under Indiana Constitution, Article 1, Section 13? And I was reminded immediately how smart the Indiana Supreme Court judges are. I didn't even think about that. Indiana affords a separate and distinct relief under the Indiana Constitution. We have a really cool and robust Bill of Rights in Indiana, separate analysis than the federal Constitution. I didn't even consider that. And that was the first question asked. And again, reminded how smart the Indiana Supreme Court justices are. Marc Lehman's response was, hey, Judge, we didn't have a time to develop this record. We filed these briefs in a record pace. And in fact, we had to come to the Supreme Court to get the record from the trial judge. So we didn't have all the time in the world. So he was kind of saying, hey, Judge, we did the best we could in the short amount of time we had. Pretty good response, I thought. Pretty good on his feet, too. I don't think he was expecting that. One of the things that caused me some concern for Richard Allen and Richard Allen's team was the judge immediately started talking about, hey, you guys are talking about a speedy trial request, but no speedy trial request has actually been filed. Apparently it's signed by Richard Allen, but not filed by the original defense team. And immediately I felt my blood pressure rise because I thought that was the judge sort of hinting that perhaps there is some objective evidence that the defense team is ineffective. They didn't really explore that, but I kind of got that impression that that's what she was talking about by not filing that and then making a claim on writ of mandamus. Not too much more was talked about the speedy deadline after that, but I did cause my blood pressure to rise for Richard Allen, Richard Allen's team. Justice Slaughter hopped in immediately and said, hey, you know what? If the trial judge is right, shouldn't these guys be removed? Isn't this the correct outcome? And Marc Lehman jumped in right away. Well, Judge, we don't know if she's right because there is not a hearing. There's no evidence. They had no time to prepare. And so there's an absolute dearth of evidence. Slaughter tried to push him to agree that removal was perhaps correct. And I don't think Marc did. I don't think Marc conceded that removal is correct based on the evidence, even if it was right. So I thought he did a great job holding up on his own. The justices did ask. So it's your position that someone can only be kicked off a case if they're not licensed in Indiana and there's a conflict of interest? And Marc fell for the trap, I thought. And Marc responded in some capacity, yes. And then the justices immediately were like, well, what about if an attorney doesn't come to court? What about if an attorney misses deadlines? Those aren't license or conflict of interest issues, but don't you agree a trial judge at some point can kick an attorney off? Again, how smart these attorneys are, because there's lots of things an attorney can do that are just terrible. And clearly not coming to court or missing deadlines, that's pretty terrible because clients depend on attorneys. Marc Lehman made a response that, well, hey, at some point the performance is so deficient, the client isn't going to want them. And so that was a pretty good response, but I will just note my own analysis. Not coming to court, missing deadlines, that's objective evidence of being a bad lawyer. There's no arguing that. A good lawyer comes to court, a good lawyer honors deadlines. Now, saying somebody's a bad lawyer because there is an evidence leak, saying someone's a bad lawyer because somebody took photos of evidence at their office and saying that makes a bad lawyer, that's subjective. That is a subjective ruling, subjective standard that needs to be fleshed out at a hearing. So there's objective, not coming to court, missing rulings, versus subjective, hey, there's an evidence link because you typed in the wrong name. Hey, there's an evidence link because your friend came and took a picture without your knowledge. Those are different. One is objective bad lawyering and one is subject bad lawyering. And there's no evidence that they wanted the evidence leak. So there is a difference between those two questions that they're asking attorney Marc Lehman. Now, you could tell that a few times that Marc Lehman was caught off guard, and that's okay. In oral arguments, and I've done a lot of these, and I've never done one in the Indiana Supreme Court, but you can want to talk about anything you want to talk about, but guess what? The judges are in control, and the judges can ask whatever they want to talk about, and you have to be ready to respond. And so what you want to talk about versus what they want to talk about, it don't matter what you want to talk about because you always got to please the audience. And the audience in this case is Indiana Supreme Court judges, and those are the ones going to be deciding this case. So they're in complete control. So I think Mike Tyson said that everyone has a plan until you get hit in the mouth. Yeah, that's what happens in the oral argument. So Marc did a great job. One point, got caught off guard, but he quickly recovered. The only thing I didn't like, at one point he was shaking that finger. Put that finger down, man. And then he quickly recovered, and then he had an open hand. That's a technical thing, but I just don't like anyone shaking a finger at me. And I thought he did a great job, B+. Now, attorney for trial judge, Gutwine. I've never met Gutwine, but I do know for a fact he's held in high regard as an appellate attorney. I mean, so high regard, trial judge hires you to argue in front of the Indiana Supreme Court. Think about that. This guy definitely is high regard. His poise and demeanor let me know he was comfortable there and he was very at ease. And I'm happy he was, because he got asked some really hard questions. Hey, don't you agree that there should be a record? Don't you agree this would be an easier situation if perhaps the judge had a hearing? And at one point, Gutwine is like, oh, the judge was prepared to have a hearing, but these attorneys withdrew. And the chief judge, hold up, stop, wait a minute. Did you read the transcript of the in-chambers hearing? It sounds like it was a foregone conclusion that these attorneys were off the case. The judge even had a script. Now, 2 points. Number one, I give the trial judge so much credit because I have never heard of a transcript for an in-chambers hearing. And, you know, even though the attorneys had to fight tooth and nail to get it, the fact that she had one, I give that credit to her, because a lot of judges would not have a transcript of an in-chambers hearing. A lot of judges have in-chambers hearing because they don't want a transcript. And this case would be so much harder for Richard Allen without that transcript of the in-chambers proceeding. And then number two, again, these judges are smart. No one's going to get one over them. Oh, there was going to be a hearing, but no, stop. The foregone conclusion, they were going to kick off this case. The Chief Justice, again, you know, the right to counsel is in the Constitution. Don't you agree that we should defer to that? Don't you agree that we should defer to the client's wishes for who they want as counsel? They were coming at him hard. Gutwine handled the questions like a true professional. The only thing I think caught him off guard is at one point he was responding to the judges, and he's like, hey, these are competent and capable attorneys. And then you can see the light bulb in his head, what he just said. And he said, in other contexts, because he's literally arguing that they're ineffective. Then he said they're competent and capable. He's arguing hard. I mean, he's doing a great job. I've never argued for the Indiana Supreme Court, but I've been in lots of trials and I've ended lots of different oral arguments. And you can kind of tell the way judges are asking questions, it's not going the way you want it to. I felt that for him. The trial lawyer inside me, it empathized with him because, oh man, I've been there before when these questions and these insinuations are not going the way I want. And he was experiencing that in real time. I saw it. I thought he was a true professional. Again, A-, B+, just true professional. And, you know, I don't know him. I've never talked to him. I got the feeling that he was there because he was hired to be there. And it wasn't necessarily what he felt in his heart of hearts or anything like that. But he did an amazing job responding to these questions. The third attorney, Sanchez, got me laughing out loud. Her interests are very much aligned with the trial judge. It's too early. There should be more evidence. At some point, the Supreme Court judges asked her some really hard questions. And she was like, oh, it looks like my time is up. And the trial, you can hear from the bench, hey, we'll let you answer that hard question. And she did. She did a great job too. Mark Lehman got to get up on rebuttal and address some comments that Justice Moulter had about, you know, hey, can't we just assign him as a private counsel? Wouldn't this solve some of these issues, not put him back on as a PD? Mark Lehman got back up there and gave an impassioned rebuttal. To be fair, he was not interrupted nearly as much in the rebuttal as everyone else was during their non-rebuttal, but he gave a passionate defense that please don't not have these attorneys get paid because it's something the trial court did. These attorneys deserve to get paid. Richard Allen deserves to have attorneys that are getting paid so they can fight hard for him. And I thought that was really impassioned. And then Mark also talked about how, in response to some earlier questions, that Richard Allen could in fact waive effective assistance of counsel based on what has been done so far. We didn't think that was a big issue. Again, I think these attorneys did an absolute amazing job. These judges, Indiana Supreme Court judges, always surprise me with how smart they are, the questions they get out there. And most importantly, if you're watching this far, please leave me a comment. Nice, mean, and a few of you did leave some mean comments last time. But leave me a comment, let me know your thoughts, let me know what you're thinking, what your impressions were, and don't forget to subscribe to my channel. But most importantly, always, plead the fifth.